Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. It's my pleasure this morning to look at a book which has come to us from the Ark Group and Wilmington Legal. This is an important book. It's in the form of a report with an executive summary, and it's been produced and actually brought together by Edward Bowes, and it has a large number of contributors. The title of the book is Practical Innovations in Legal Pricing. Very important area, because when we're quoting for work, it's always a particular art. I'm not very good at it, and many people, many barristers aren't. That's why we have clerks to do the work for us. It's not the easiest thing to know, because quite often you don't know what it's going to cost. However, the title we've given for this book review, which Elizabeth and I have written, is Appropriate Charging for Legal Services, Many a Conundrum Solved. Well, we'll look at that without giving too many spoilers away in a minute. Let's look at the book first of all. There it is. There's the front. There's the spine. And then on the back there's a little bit of blurb which explains, bringing it up quite closely to you. You can see it there. It's a little bit of information about the book itself. There's no index at the back. It runs to 91 pages. You can see you've got some subheads there. You've got some referencing. No footnotes, fortunately, which makes it easy to read apart from anything else. There's the front page there. Then you've got the blurb about Ark. Then the chapters. There we go, each chapter. Each chapter has the name of the person who's written the actual piece. And the total number of chapters, 10. We've got the names of all of the people there. Then there is the splendid executive summary, which sums up what this book is actually all about. And then after that, it's not a long executive summary, so it's easy to read. Then you've got all the detail about the authors. I can't go through them name by name, but you will see they're all a large number of people there. Some names I'm sure you will know from reading other books from other publishers, all much in a similar vein as we enter the new fourth industrial revolution. There is the chapter 1 heading. It's the roles and responsibilities of the pricing director, and this is obviously for bigger firms, and it gives you a lot of very substantial detail. For instance, here's another chapter 5, designing an object orientated fee arrangement. There we go. Now, can I just say that this is obviously for larger firms, and it is very much a management book apart from anything else, but it will give you tips about pricing, in other words about quoting for particular work. Now, it doesn't necessarily apply for people like myself as barristers at law, because we have a slightly different system. But certainly for large firms looking at fairly substantial clients, this book will be a godsend, I think, a little goldmine of information for people who need a little bit of a steer in the right direction, because it is an art, and we'll look at it in a bit more detail. This is what we say. Better for the client, better for the firm. This is the delicate balance that every practitioner or law firm must achieve when the vexed question of pricing raises its head. All the more reason why lawyers, mainly of the corporate variety, I hasten to add, tasked with running a law firm as a business, will find this new title from the Ark Group and Wilmington Legal as a compelling and instructive read. I certainly did. It's not a long book. It's easy to read, and it's got a lot of common sense in it. Now, it's been edited by David Bowes, who heads a team of a dozen expert contributors, and the book is all about how you can and should charge a fair whack for your work. We'd all like to do that, wouldn't we? But the thing is, it does give you some good indications of what to do. And in many ways, it will probably reassure you that your pricing policies are right. And in other words, it will point out areas where you might be going wrong. Read the book in detail. I'm not going to give you spoilers, and you might be persuaded that pricing is, or at least should be, a separate discipline for which specialist advice is needed, especially for matters that will evolve over time. And remember one thing, I certainly feel, if you don't get it right and you lose the business, you think it's all your fault. I just say it's not necessarily like that at all. You've got to remember that the client, the customer, has their own concept, their own policies. So don't necessarily think that it's all your fault. Now, ideally, pricing should be based on objective criteria, objectively arrived at rather than on, for example, the traditions and customs prevalent in many legal environments. Although when you consider all the variables involved, pricing can never be an exact science. Of course, with me, as a contentious litigation advocate, as a barrister at law, a lot of what we do, of course, is regulated by the government by means of fixed costs and so forth. However, let me go back to this because we're talking now about the larger law firms, both here and abroad. What this book provides is a range of experience-based advice and commentary on certain underlying principles and strategies of pricing that will demonstrably work to the satisfaction of both law firm and client. And to this end, just about every conceivable aspect of pricing is covered, illuminated throughout by helpful case studies. And this is indeed, in the editor's words, a comprehensive overview of best practice in innovative pricing. And that's what you're getting. As clients become increasingly proficient in negotiating costs, he says, service delivery must be framed by value, expertise and profitability rather than hours billed alone. And I would add to that I'm certainly seeing from the government downwards and the Ministry of Justice that this is the approach that they would like to see, certainly in the United Kingdom. And we'd be moving away from this sort of hours billed concept very much to the overall picture. And that is certainly probably going to be the case when we finally see the Jackson supplementary report implemented in part. That's to cover the what he calls the intermediate and the multi-track cases in the county court. Now, I say that just specifically for England and Wales people, representatives and so on, anybody involved in. The reason for that is purely and simply that I think there is a general move away from the hourly basis for what we do. It's not necessarily the case, and obviously it does have its value, but it's certainly what the client will normally ask for. But when you look at some of the work we do today, it's very difficult to do it in terms of that sort of precision. Now, the book, just to move on, therefore offers a number of thoughts on underpricing, which is another area of problem for all of us, where firms can be tempted to do just that to acquire more business. You know, in other words, the standard thing, oh, well, there's plenty more work where this came from. Yeah, well, we've heard that one before. The thing is that don't be fooled by that type of approach. Of course, these can range, as I said, from discounting to suicide pricing, which can put firms out of pocket. And there are any number of other negative comments on the effectiveness or lack of it of discounting, which should provide ample support to those lawyers who remain sceptical that there is any benefit in discounting professional services. And I will say to you now, I don't. You've got to pay your lawyer a proper amount of money for the work done. And if, as you get with some customs in some cultures and some countries, where they think they can want a discount later on, or they want some money back or something else, it doesn't work like that. If it did, I suggest you're putting your professional integrity into some dangerous area. If you think about it, that is a problem. So therefore, when you come to think of underpricing, sure, you can give a package, but don't go down that route, because it doesn't help the profession apart from anything else. Let me just conclude, having given you a little bit of a view of the Taylor view, if you like, on that. Do read the book, because it's far more important than what I have to say. The book's final chapter, for example, cites psychological and even biological, would you believe, evidence to support their view that too much discounting makes clients uneasy and is counterproductive to retaining client loyalty. As for reduced hourly rates, note well that increased cost efficiencies are, for obvious reasons, a much better idea. As I've said, we are moving away from that, I think, at the moment. And also some clients know what the market rate is. And I think if you don't charge the right rate, they're going to smell a rat and think, well, just a minute, what's going on here? Are we going to get a dud giving us the advice? The answer is you know that you've got to pay for what you get. So for the details, buy the book. The practical insights it provides on the crucial matter of pricing could prove invaluable, we think, in helping you raise the profitability of your firm. And that's really what Edward has aimed to do with this book. Publication date is cited at 2017. There's the book again, front, then there's the spine, then there's the bit on the back. Just opening it in the middle, I've got, here we go, this is, it's all about expertise and outcomes, knowing what to do, litigation. I know we come to litigation because I'm dealing with the review. Workplace disputes and compliance. So you've got a huge amount of questions, and I think basically most of the questions that you would have are answered in this and the other books in the series which Ark have produced this summer 2017. I'd like to thank everybody concerned for producing them. They're very useful books and extremely helpful to us in the running of our businesses, our legal businesses. Thank you to all. Bye-bye.